petitioner is not even a borrower. The property is not under mortgage. It's a fraud for which the petitioner has become a victim of that fraud. And attachment notice has been issued by the recovery officer. My lord, when urgent, it might be attached any time.
Give the memo, we may reach tomorrow.
My lord, grateful.
After the process of more than 8 years.
My lord, the petitioner is jail over 18 years.
Hmm?
The petitioner is in jail 8 years. My lord, bail is pending.
The petition challenged the order of the Learned Tribunal. Yeah. This matter relating to regulation. And
Give them. Yes.
item number 1, your lordship. In that case, I found that material particulars have been omitted. So, may I be permitted to withdraw it with liberty to file a better application with better particulars?
Mr. Vishwal and counsel appearing for the petitioner seeks permission to withdraw this writ petition to file a better writ petition, better particulars, disposed of as withdrawn. Yes.
Oh, it's urgent copy, your lordship.
Yes.
Supplemental list, item number 2.
Right, please, your lordship. My lord, this is a case cover your lordship's judgment, my lord. So far as Naruttama Ratha case is concerned, having bearing number WPC 1608 by 2014, may kindly peruse, my lord.
What was the challenge here? And already functioning under the You, Mr. Have you served with a copy of the list? Please go through it. We can verify it tomorrow. See what is the prayer in this, whether it is similar or not. Then we can get from the learned counsel for the petitioner has produced the judgment copy in the case of Narottama Ratha versus State of Orissa, WPC number 16,000 and which was disposed of along with the patch of the petition. And submits that this case is covered by the petition granted in the aforesaid case by the division bench. Let a copy of the judgment be handed over to the learned counsel for the state in course of the and the matter it will be taken up tomorrow. This time. Monday. Okay.
Item 3.
May it please, your lordships.
Initially, the land belongs to the grandfather of the petitioner, my lord. That was acquired by the government of Odisha for creation of a new Bormunda village, so also the farming society, my lord. Now, it is mentioned at the schedule of the land at para 7 at page number 4 of the writ petition, my lord. And when the government assured that in fact, the petitioner and similarly situated persons are farmers, my lord, and they did not provide them the substitution land. For that reason, they have represented before the authority by the time, my lord.
What's this third report of the committee for?
My lord, pursuant to the direction of the Odisha Legislative Assembly, there was a committee constituted.
The committee has been constituted to take up the matter case to case basis.
My lord. And the recommendation is that, your lordship, at page number 37, your lordship, may kindly see the relevant portion of the recommendation of the committee. The last paragraph, 2.8, my lord.
At paragraph?
Page number 37, my lord.
37.
The last paragraph, 2.8. May be permitted to place it for a moment, your lordship. The committee is further inclined to recommend that the extent of 250 acres of land allotted to Boromunda Joint Farming Cooperative Society should be taken back by Revenue Department and lease out of the same to the affected farmers. I am one of them, my lord, of Boromunda, whose lands have been taken over by the government, my lord. This recommendation of the legislative committee was not thereafter, my lord, via Annexure 6, page number 38. The then leader of opposition, led Biju Patnaik, requested the secretary to take needful steps, my lord.
What you have done recently, what you have submitted any representation?
My lord, we have submitted a representation via Annexure, my lord.
9.
9, my lord.
That is one person. One person has signed.
My lord, it is only one person. The petitioner here before your lordship is.
So that you want to dispose of. Okay.
My lord, let the chief secretary take up the matter, my lord.
Next 9 to be disposed of, 3 months, and order to be communicated. Yes.
Oblige your lordships.
Item 4.
I think 4, 5, 6, 7.
May I please, your lordship? Annexure 3 is pending before
Eight.
the OP number 3, my lord.
Yes, sir.
Covered matter.
6. 4 to 8.
Item 9.
May I please, your lordship? I was too late, my lord, I could follow. Now the petitioner challenges the judgment under Annexure 1 of the Central Administrative Tribunal, in which his promotion from the cadre E, cadre 6 to 7 has been rejected, while his juniors had already got the promotion, and now the petitioner has already been superannuated from the service, my lord.
Just read the operative paragraph in
Judgment, my last portion.
yes, sir. Paragraph 20 and 29.
Paragraph 20 I am placing.
Yes.
The applicant in this way is trying to evade the provisions of EPAS, and that is promotional rule, in which the activities of the ARS starts from the distribution of blank appraisal and ends finally being accepted by the accepting authority. The ARS annual appraisal report, ARS would be incomplete without being accepted by the authority. His representation and appeal for declaring the rating given by the cadre controlling authority and accepting authority as null and void has been rejected, and those ratings were rejected by the appellate authority, not by the court. Rejected, and those ratings have become final.
applicant in this way, instead of seeking direction for review of the ARS, is seeking direction not to take into account the ratings given by the cadre controlling authority.
There was a scope for
Yes.
review. No.
Yes,
There
there
was a scope for review. So you did not avail it. In spite
No, because the matter was pending before earlier for a direction for mandamus direction, but the representation was pending. That was not considered. So I have taken shelter before the cat matter for direction.
No, against our question is that against the appellate authorities decision, there is a scope of review, and that you did not avail. That is
that he has taken the stand that by limitation affected. I have challenged it in the year, the order was rejected in the year 2015. I have challenged it in the year 2020. So that's why he has, but due to limitation, he has rejected my prayer.
No, you continue there.
My lord. The applicant in this way, instead of seeking direction for review, I have my prayer mail there. Review of his ARS is seeking direction not to take into account the ratings given by the cadre controlling authority and accepting authority and conduct review DPC, keeping the score of moderation committee and giving him promotion. Whereas the applicant has not quoted any provisions of rules under which that prayer can be accepted apart from the process of EPAS, which does not provide for the same. Well, there is no next matter. Awarding of grading and reviewing, it is the discretion of the authority, and it's not for the tribunal to decide on what grading the employee should get or whether the grading is commensurate with his work profile. There is next page, my lord. Considered his appeal and rejected it as per company's rule and policy. This tribunal does not find any illegality in it warranting interference by this tribunal. Since the appeal of the applicant for review of his ARS was rejected and the same having attained finality, the rating given in the said ARS stands as per the as of today. Therefore, since the original ratings remain unaltered, the question of conducting a review DPC does not arise. My question is, they have never gone into the inside factor of the rating, my lord. In the rating, I haven't discriminated.
No. Question is that when the authorities have given you the grading,
my lord,
okay, they are the best persons to adjust that.
That can be reviewed. They have.
So unless there is,
they have applied the gross mile.
What is the rule?
My service, my lord.
Where is the rule and where is the specific government that what do you say that it's a case of malafidness and gross? So how did you substantiate it so that that can be interfered with? Because the authorities have given you a grading, they must have collected the materials on the basis of which, let us say, you have been given grade B. Let us say, for example, you want that my grade should be A. But for that, you have to show us the materials that yes, this authority was given this mark. They malafidely, they are more gross against me, and there must be some material not near.
Yes, my lord. My appeal. My lord, first of all, they have given the.
ଖାଲି କହିଲି ପରା ଆପଣ ଆଭରମେଣ୍ଟ ନେଲେ ଖାଲି
ନା appeal ମୁଁ ଫାଇଲ କରିଛି. Appeal ଟା ଫାଇଲ କରିଛି, ସେ appeal ରେ ସବୁ ଡିଟେଲ ଲେଖିଛି କାହିଁକିନା they have never intimated me my rating. Before DPC, it is the rule that they should intimate me what my rating was.
You are not able to understand what my lord.
My lord,
see, in every rating given by the court cannot review it. It's a personal rule prevalent in the company. And unless you make out a case for malafide, we are not going to review it.
My lord,
how can you maintain this rate?
My lord, that is the my answer is that because they have never communicated me my rating.
The persons who are in the helm of affair,
my lord,
an employer, he can know that who the employees whether he is entitled to get the grade, a particular
correct.
grade or not.
Very correct.
So they have to make the necessary assessment. The court cannot judge that what grade you are to get, right? Unless you say that, yes, you see my grading prior to that, this, and deliberately, because of this reason, nullifiedness, I have deliberately been given. So unless you bring out such material, how the court will say that
Well,
this
another
grading was improper or illegal?
tribunal has rejected my prayer. But in the judgment, my lord will find that rejected my prayer on the 2 grounds. On the question of limitation, that I have not immediately asked the challenge their action. Number 1. Number 2, I have not made the parties to those persons who had availed the promotion, my lord. In the judgment, there is clearly it is evident.
No.
You have just read out.
I just requested made a prayer for review of the rating.
Whatever
They have given the rating. I only
paragraph conclusion paragraph पढ़िले आपण
Minor. ତା ଦେହରେ ନାହିଁ।
submission କରୁଛନ୍ତି ତା ଦେହରେ ତ କିଛି ନାହିଁ. These are the concluding paragraph. Why?
On merit.
On merit they have decided. So the other things which you have stated, that is not, the conclusion is not based on that. The conclusion is something different, which you just placed before us in paragraph 28 or 29. So how a court will say that the grading which has been awarded a particular person is wrong, or it is deliberately done, it is illegal, or there is some malifiedness, unless you take that ground and substantiate it.
I have challenged the entire fact because they have never communicated my rating. I could not know my position. When I know my position,
find out
immediately I have filed the appeal.
In which paragraph of your petition, writ petition you have?
Let us see that
Which
where you have
paragraph?
stated that you are never communicated and everything was behind your back, for which you could not make early representation, and that is the reason why there was so much of delay. You said that the grading was given in 2015, right?
My lord.
And you raised this issue for the first time in 2020.
20.
20 or 22?
2020.
5 ବର୍ଷ
5 ବର୍ଷ କାହିଁ
5 ବର୍ଷ ଆପଣଙ୍କର ଯେତେବେଳେ ଗ୍ରେଡିଂ ଦିଆଗଲା, ଆପଣଙ୍କୁ କୌଣସି କମ୍ୟୁନିକେସନ ହେଇନଥିଲା ତା ଭିତରେ?
My lord, paragraph 5, my lord, of my brief, my lord. In the above context, but mentions that for the promotion from grade 6 to grade 7, the Departmental Promotion Committee was held in the year 2013. As per rule, for the said DPC, appraisal marks of 2010 to 11 and 11-12 and 12-13, and for DPC 2014, the above said marks along with marks of 2013-14 are to be considered. It was the rule that the appraisal marks are to be communicated to the employees before deposition. But the petition was never in any appraisal mark. Before the DPC was held for promotion of grade 6 to 7.
Read out the next paragraph. Read the next paragraph.
My lord, in the mention here that through RTI, the petitioner came to know that his serial number was 7 in the gradation list, where as his juniors named one S.R. Patnaik and B.K. Swai and R. Waris are placed at serial number 33, 43 and 44.
So thereafter?
Then what happened? Next paragraph.
That the above said juniors of the petitioner were promoted on dated 6 to 2015 from the grade to the E6 to E7, ignoring the petitioner, as the petitioner came to know from the reliable sources. On date 10-9-5-2015, final gradation list was published. It is pointed here that in the said list, petitioner's name was placed at serial number 7, whereas his junior's name were placed at serial number 33, 43 and 44 respectively.
Okay. Did you take this ground in your
appeal? In the appeal and also
in the original application which has been filed before the Central Administrative Tribunal.
Yes, madam.
Which is that ground and what is the reply? Where is your petition? Where is your original application?
I have not annexed my lord.
And they must have filed also the counter to that.
Yes, my lord.
So file both of it. Let us file. Let us know that whether that stand has been taken or first time taken in this.
Initially, it was not taken because it was not in the list. My initial
Which has not been taken before the.
right, cat I have taken, my lord. Miscase, my lord.
ଆପଣ ସେଇ ଯୋଉ ଅରିଜିନାଲ ଆପ୍ଲିକେସନ ପ୍ଲସ୍ ତାଙ୍କର କାଉଣ୍ଟର ଆଫିଡେଭିଟ ପେନି ଯଦି ତା ଉପରେ ଆପଣ କଣ ଦେଇଥିବେ ସବୁ ଗୁଡାକ ଫାଇଲ କର ହେଲା and give a copy to the other side also. Who is appearing for the other side? It was central. So,
Union of India.
Union of India, anybody is there? Copy service କରିଛନ୍ତି?
हाँ, notice टे जाओ ना.
No, not in that way. We must be satisfied that you have a case. Issuance of notice is not a routine thing. Yes. Have you served a copy so that we'll record it?
Yes, I have served my receipt is with me.
All right. The learning counsel for the petitioner submits that he has served the copy of the petition on the land central government council,
Central Government Council.
on the Deputy Solicitor General the receipt produced before us. None appears the side of the opposite party. However, since during course of argument of the writ petition, learned counsel for the petitioner its permission to file the copy of the original application counter affidavit if any filed by the opposite party. This matter is urgent to be commencing from 20th of August 2024. The name of the Deputy Solicitor General will be reflected in the body. Yes.
like that.
Item 10.
Item number 10 and item number 20.
So Delhi पर से तो चीज को जब साइक्लोसाइड would order ही वो कोई देवन कॉपी देना
Item 10.
Item number 10 and item number 11 matters. Both the matters the acting judge may be taken up before any other bench. May be taken up before any other bench matters. The manager is concerned in this case matters.
Who is concerned?
My manager is S.K.Sahoo.
Yes, yes. Who is he? Dipti Maheshwari.
The preliminary inquiry was conducted.
Yes, yes, yes.
Was conducted by your lordships.
Yes,
Because
yes.
which the petitioner was placed on.
All right.
10 and 11.
Yes.
All right. Is this matter before any other bench in which one of us, Honorable Justice Swanson, here, not a party.
Great.
Item 12.
Concern is to be said by the judge of the party. Concern is to be said by the judge of the party.
Yes, next.
Item 12.
Please, Your Worship. The
Yes, Mr. Behra.
my lord. Then the land of the father of the petitioner has been acquired for the construction of lower Indra irrigation project Khariar in the district of Nuapada. As per the rehabilitation and resettlement policy, the government under Annex 1 running page 15 decided to provide
Next
some
of 15.
running page 15 Annex 1.
Yes.
The government have decided to provide some assistance to the
Please
family.
place that operative. You are therefore requested to food opportunity.
Running page 15.
Running page 15.
Annex 1.
Sorry.
For the second paragraph. You are therefore requested to consider the applications of only those cases who are eligible for RR and benefits as on 1/1/2014. That the cut-off date decided by the government was 1/1/14. As per the direction of the government, a survey was conducted. And prepared a metric list. As per the list under Annex 2, running page 22, Your Lordship, that the name of the petitioner is placed as serial number 84. Running page 22, Your Lordship.
Submission of list of displaced families as per letter dated so and so. Annex 1.
Annex 1.
Acha. So your name finds place here.
Running page 22, serial number 84.
Serial number 84.
My lord.
Rajendra Dar.
Rajendra Dar.
Okay, then what happened?
The compensation provides some compensation assessed to 7,41,200. After the collector has recommended the matter to the director for sanction of the said amount. Running page 24, serial number 8, Your Lordship, village Daraga, 92 numbers of displaced family and a sanction for the amount. That no amount has been paid to the petitioner, so therefore petitioner approached before Your Lordship. Your Lordship, this Honorable Court directed under Annex 3, running page 27, Your Lordship, operating person. Running page 27.
3 no 4.
Annex 4.
What direction was issued? Please read the operative part.
Yes. Considering the above, this court disposed of the writ petition with a direction to the director RR and additional secretary to government, Department of Water Resources, opposite department number 2, to sanction the proposal submitted by the collector Nuapada, opposite department number 3, had letter dated 6th December 2017 under Annex 2 for payment of the rehabilitation assistance in favor of the displaced persons of village Darga under lower Indra irrigation project Khariar as expeditiously as possible, preferable by end of November 2023. But till that, no amount has been paid. Therefore, petitioner has filed a contempt application. During the course of hearing of the contempt application under Annex 6, running page 29, the special LO has submitted a report that has rejected the claim of the petitioner on the ground that running page 33, Your Lordship. Sufficient document in support of date of birth is not submitted. Running page 33. Rajendra Dar not eligible.
33.
33.
Sufficient document in support of date of birth.
Yes.
Not submitted.
Submitted.
So what is the necessity of that date of birth?
Date of birth, Your Lordship. As on cut-off date, the petitioner should have been above 18 years.
Okay.
Therefore, I submitted my date of birth certificate. Here also, running page, the matrix, running page 22, serial number 84, clearly mentioned to as on 1/1/2014, the age of the petitioner was 22.
Serial number
84. The age of the petitioner as on 1/1/2014, 22 years.
No. What is the document he is saying? Document कौन दिया है?
Document I filed my birth certificate under Annex
Annexure.
Where is annexure 8?
Yes, Your Lordship.
ସେଟା ହଉଛି ଆପଣଙ୍କର
Birth certificate was issued only on 17, 2017.
ତ ଇଏ ହୁଏ
My date of birth is 30/10/1992.
ହଁ ରାଜେନ୍ଦ୍ର 92 ହେଲେ ସେଟା
22 years.
କଟ ଅଫ ଡେଟ୍ କେତେ
1/1/2014.
ଆଉ 3 ବର୍ଷ ପୂର୍ବରୁ
14/8/22.
ତ କଣ ପାଇଁ ରିଜେକ୍ଟ କଲେ in this in this petition the petitioner Rajendra Dol alias Rajinder challenged the rejection of his claim for payment of revised estimate amounting which is 8,26,000 towards rehabilitation assistance to the displaced families in village Dorgaon due to construction of lower Indra irrigation project Karya. With a further prayer, the direction to the parties number 2 and 5 to pay the such revised estimate. The land council for the petitioner to the attention of this court to annexure 2, which is a list of displaced families prepared by the who has prepared this list.
Your Lordship.
It is prepared by the of the director from no, this is the letter.
Project director, collector,
project
zonal
director,
officer.
R&R,
committee tawan.
Indra irrigation project Kamak Pariya office of this one so upar likha hai ji, wherein the name of the petitioner finds place in serial number
84.
120 and it is specifically mentioned that as on 1/1/2014 the age of the petitioner was 22 years. He submitted that since the said amount was not paid to the petitioner, the petitioner approached this court in WPC number 17509 of 2023, which was disposed of on 10/8/2023, directing so and so operative portion let the paragraph 5 page number 27. The land council submitted that since the order was not complied with, the content petition was filed,
Which was later withdrawn.
which was disposed of as withdrawn. Contempt number with the CONTC was disposed of as withdrawn on 15/7/2024. And on 26/4/2024, the intimation was given to the petitioner by later dated number so and so 26/4/2024 under annexure 7. The special LS one so intimated to the that mentioned that you are who paragraph mentioned is
Running page 30.
30
33.
अच्छा
Order करछन.
26/4/24.
26/4/21. That the petitioner is not eligible to get the amount in question on account of non-filing, there is absence of sufficient document in support of the non-submission, like non-submission of sufficient document in support of the date of birth, and accordingly the claim was rejected. The Land Council for the petitioners to the attention of this court to the birth certificate of the petitioner under Annexure 8, which indicates that the date of birth is 30/10/1992, and as such, petitioner was 22 years as on 1/1/2024 and
1/1/1014.
2014, sorry, 1/1/2014, and it is the submission of the Land Council for the petitioner that the annexure to rightly reflected the correctly reflected the age of the petitioner, and therefore the rejection order notice on the question of admission indicating that the matters shall be disposed of at the stage of admission. The Land Council for the state accept notice for all the opposite parties.
All the opposite.
Mr. Mishra, you are accepting notice for all the opposite matter be listed. Let it come in the month of September and you obtain an instruction on this matter to be listed in the commencing from 2nd September 2024. Counter affidavit if any. Yes.
Yes.
Extra copies.
Thank
Five extra copies.
Five extra. Obliged to us.
Nowadays, it is actually these orders are not passed because you have to communicate to the authority by that's one copy. One copy. Only one copy with all the annexures we provided to the Land Council.
Item 13.
Like 2 weeks time I will contact for getting the certified copy which is
There are so many defects.
file but only the certified copy record in the old.
So you remove the defects, huh?
Yes,
How much time you want?
2 weeks.
Kiran Raut and counsel appearing for the petitioner takes 2 weeks time to remove the defects as pointed out by the stamp report. This matter after the defects are removed.
Item 14.
I directed to get the original records from the authority man.
ये जो revision
Board of
case वाला हाँ
Board of
ସେତେଠି କି ମତେ ଆଉ ଦୁଇଟା ଯୋଉଦିନ ସେ ଆସିଥିଲେ ରେକର୍ଡ ନେଇକି but the record which my lord wants that was not.
when we made a query to the Land Council for the state about the whereabouts of those petitions and the order sheets, took some time to produce the original case record. आपण आणिଥିଲେ ତା ଦେହରେ ନଥିଲା introduction. So then if you want 2 weeks today is 7 September 2 Land Council for the state 2 weeks further time to produce the original case record of settlement revision number 88 of 1992. So also list case number 28 of 1990. Proceed. Okay. This matter. 2nd September 20.
Item 15.
Yes, Mr. Das.
Yes, my lord. This is with regard to closure of account number 8400765425. Last occasion, Lordship has directed
My learned friend to produce
Just a minute.
the balance amount.
1/8/2014.
Yes, sir.
I'm considering those two pairs have been made in the with not raising the pair number one. So for us, pair number two is concerned, it is as follows. Okay. And counting the submission of right filing the counter rate of it was indicated in the sure. The outstanding and the judgment of the country. And from the produced documents and documents are taken under the copy of it. And then obtain specific instruction whether any further amount is out. Yes. On and off mode will come.
Now the loan outstanding due is 3,293. Now the loan outstanding dues is 3,293 as on today.
Anisang coincidental charges has to be paid.
They have addition supply advocate fees along with my so far as loan outstanding is concerned, 3,293 is due on me.
Balance amount is payable by the bank. Balance amount is paid in by the bank. So ultimately the fixed rate. So two
ଏଗୁଡ଼ାକ ସବୁ ଲୋକ ଅଦାଲତରେ ସେଟଲ ହବା କଥା ଆପଣ ଯଦି କହିବେ ଏଠି ସେଟଲ କରିଦବା ନଚେତ ତାକୁ ପାଇଲେଣି ସବୁ ସବୁ ଆମାଉଣ୍ଟ ପାଇସାରିଲେଣି ଏଗୁଡା ଆପଣଙ୍କର ପେପର ପବ୍ଲିକେସନ ଆଡଭୋକେଟ୍ସ ଫି ଏଗୁଡାକ ସବୁ ତାହାକୁ ଯଦି ଆଦାୟ କରି ସବୁ ମ୍ୟାଟର
district commission ସବୁ ସେ କେସ୍ କରିଛନ୍ତି ସବୁଠି ଆକ୍ସେପ୍ଟ
ଏଗୁଡାକ
ଆଉ there is another loan account in name of the overall husband. The KCC loan I mentioned in my name also in counter detailing file. Another time see the contract of the
ସିଆଡକୁ ଯାଆନ୍ତୁନି ଆପଣ whether you are entitled to this amount first of all paper publication charges surface charges advocates fee এটা କୋଉଠୁ ଆପଣଙ୍କର
possession notice is published
no how do you claim that you are entitled to all these things from the petitioner on is there anything as per your banking rules or is there any judgment law that you are entitled to get whatever you publish in the paper that is to be
I take instruction
କାରଣ ଆପଣଙ୍କର ଆପଣଙ୍କୁ ବ୍ୟାଙ୍କ ଯୋଉ ପେମେଣ୍ଟ କରୁଥିବ ଆଜି ଯୋଉ ଆପିୟର କରୁଛନ୍ତି ତା ପଇସାଟା ସିଏ ଦେବେ ଏ କଥା କୋଉଠି ଲେଖା ହେଇଛି ଆପଣ ପକେଇଛନ୍ତି ନା ଆପଣ ଆଡଭୋକେଟ ଫି ପଡିଛି ଏଠି 12,000 ଟଙ୍କା ଆପଣ ଆପଣଙ୍କ ଫି ଟା ସିଏ ଦେବେ ଏହା କହୁଛନ୍ତି ଆମକୁ
No, that in the event of a dispute between the parties, the entire charges to be borne by the bank has to be reimbursed by the borrower. Eta koti achi.
ଦେଖ
ପବ୍ଲିକେସନ ସମସ୍ତଙ୍କ ବାହାରିଛି ଆଉ 5-6 ଜଣ ବରୋର ବି ଅଛନ୍ତି
Eta proportionately that's
the learning council for the opposite parties filed memo please take instruction appropriate instruction that wherein it is mentioned that the out of the loan outstanding is 3,293 but including the paper publication charges and surface charges advocate fee and deducting the amount already paid by the petitioner the balance amount comes to rupees 43,021 he is concerned with only with this particular loan, HBL account, not the other one.
Not that.
Okay. So the when a query is made to the Learning Council for the to the Learning Council party, that under what authority the bank is charging paper publication charges, suffice charges, advocate's fee from the petitioner, the Learning Council for the opposite party seeks some time to obtain instruction in that respect. List this matter in the week commencing from 20th August 2024. Instruction be obtained in the meantime. This is taken on record. Yes. आगे सीरियल में जाते अपने भी पास लोग पैसे हमें बोलने हो जाएगी तभी से तो ताकि हम टोटल मैटर भी पहुंचा तो ताकि ना अपने बैक करिए
Weekly list item number 33.
My lord, item 43, I already filed this counter affidavit and already served this copy, my lord, of the my lord.
Which for the petition? You have received the counter appeal. Do you intend to file any rejoinder or all right?
My lord, I saw filing this hard copy, my lord. Hard copy.
The Land Council appearing central government. You are Mr. Padhi, no?
B.K. Padhi.
Mr. B.K. Padhi, Land Council appearing for the Union of India, filed the counter affidavit in court, which is taken on record. Copy of the counter affidavit has already been served on the Land Council for the petition, who sits 2 weeks time, file 1 week time to file this under if any decision. So this is matter in the week commencing from such and such date. Draft affidavit, if any, be filed in the meantime, serving copy on the Learning Central Government Council. Yes, please. Date reason. Yes, today it is this. हाँ जबका जीव जो सारी देला परे बैक करिवो हम सेति पई हमें 20 टक एडजस्ट कर दू तापरे जोड़ा 500 करे दिता yes
Item 44.
yes
Yes, for in front of the limited amount which is deposited by him for purchase of the property as per the auction list. And my learned friend has taken time last occasion to take instruction in the matter.
what is your instruction?
What happened, my lord? That being successful bidder, he could not deposit the entire bid amount within the time stipulated under the law, my lord, within the 90 days. First, he has to deposit, my lord, 25%. Thereafter, auction sale will confirm, and the rest 75% he has to pay within, my lord, next 15 days, and subject to extension maximum 90 days,
Yes.
as per the rule 9.
Yes.
And he prayed for an extension.
Rule 9 means let us see. Take this.
As you can see, security interest enforcement rules, my lord. Page 66 and 67.
Boy का कितने number page है?
66, my lord.
66.
My lord.
हाँ.
Rule 9, sub rule 3, my lord. On every sale of immovable property, the purchaser shall immediately, that is on the time, on the same day or not later than necking day, as the case may be, pay deposit of 25% of the amount of the sale price, which is inclusive of earnest money deposited, if any, to the authorized officer conducting the sale, and in default of such deposit, property shall be sold again. My lord, next sub-rule 4. The balance amount of purchase price payable shall be paid by the purchaser to the authorized officer on or before the 15th day of confirmation of sale of the immovable property or such extended period as may be agreed upon in writing between the purchaser and the secured creditor, in any case not exceeding 3 months. My lord,
In this case, what happened?
in this case, my lord,
When that was first that sale was
my lord, 29/8/2022,
on 3/8/2022
my lord.
ସେଇଦିନ ସେ 25% deposit
ନାଇଁ ସେ earnest money deposit କରିଥିଲେ
ଆଚ୍ଛା
10%, thereafter 15% deposit kale
just a minute.
on 5/9/2022.
Earnest money deposit କରିଥିଲେ, that is the 10%,
ନାଇଁ lord,
and balance 15% କରିଦେଲେ ସେଇଦିନ
ନାଇଁ te
29
5/9/22 ସୁଦ୍ଧା କରିଥିଲେ
ଓ
ଏବଂ
5/9/22
ନାଇଁ lord, ଏବଂ 5/9 ରେ sale was confirmed.
ଆଚ୍ଛା 30/8 deposit କଲେ ଆଚ୍ଛା ତ
On 5/9/2022 sale was confirmed.
ହଁ ଠିକ ଅଛି।
My lord,
ତ 5/9 branch manager requested the petitioner to deposit the amount, that means balance amount.
my lord, 75%.
Acha, 75%
My lord.
within 15 days. That is as per the rule.
My lord,
Then what happened? Petitioner requested.
requested on
Okay.
15/9/2022,
Okay.
then 15/10/2022,
ଗୋଟେ ରିକ୍ୱେଷ୍ଟ ହେଲା ଆପଣଙ୍କର
15/9/2022 ରେ
ଏକ୍ସଟେନସନ ଦିଆଗଲା।
my lord,
ଏଇଟା ଦିଅ ଏଇ
up to say 26/9.
just a minute.
My lord,
ଏଇଟା ହଉଛି 15/9/22 ରେ ହେଲା ଫାଷ୍ଟ ଏକ୍ସଟେନସନ।
my lord.
Then
Then
ଆଉ ଗୋଟେ ଆପ୍ଲିକେସନ ଦେଲେ।
the land was mortgaged before the bank, which was registered before at Calcutta mine. That is the whole problem creates, for which the petitioner was not able to see information of property, and he had applied for the loan for the self-same bank. They have denied the same, stating that the property has been mortgaged registered at Calcutta, so it cannot be mortgaged here. But the self-same mortgage property they have sold it. That is the fact of the case for which the property, the rest amount would not be deposited by the petitioner.
Okay, whatever it may be the reason. So you submitted a representation with a request.
Property was registered Calcutta in the year
The petitioner submitted, come to the order dated that 6/3/23. Read that, the petitioner.
Submitted a different direction of this one court, my lord. They approached earlier, this one court directed to approach the bank, and they have rejected it by the order by their letter.
What order was passed by this court?
The lordship
On 15th. Annexed 10. Let us see that order.
Since the matter arises out of contract, this court is not inclined to it. However, liberty is granted to the petitioner to pursue his remedy by approaching the bank after the matter. Thereof the petitioner submitted the representation, and that has been rejected by the annexer 12 match. Stating that as per the rule, you have given 90 days time, but you are not able to deposit this for which it is.
So now what can be done?
As per rule 9(7), if there is any encroachments, then where the movable property sold is subject to any encroachments, the authorized officer may, if the things fit, allow the purchaser to deposit with him the money required to discharge the encroachments and any interest due therein, together with such additional amount that may be sufficient to meet the contingency for the cost, expenses, and interest that may be determined by him. In this case, what happened? The property was initially registered before the sub-register of Calcutta. So for that reason, that was not disclosed in this notice, and subsequently it is not known to the petitioner also. When the petitioner applied the loan same bank, and they disclosed that it has been mortgaged it has been registered at Kolkata. For that reason, it could not be taken as equitable mortgage, and no loan will be announced in your favor. Thereafter, the petitioner approached Bank of Baroda for the loan on the self-same ground that has been rejected again.
So they had, you meant to see that the very self-same property that was kept on mortgage and loan was sanctioned in favor of the first person
But not
who was defaulted. But he defaulted or everything, you took that property. They did not allow you loan on that.
And none of the banks also allow the loan on view in view of registration at Kolkata. That same platform. For that reason, the petitioner approached them.
So, are you not aware of these things? It was
not been mentioned in the cell notice as well as not. For that reason, my learned friend has taken. I have told him to file an affidavit to that effect so that it can be adjudicated.
You have taken those grounds in this writ petition.
Yes, sir.
My lord, first of all, what was admittedly registered at Kolkata and it is mortgaged to the bank. And my lord, in the auction sale notice, lordship will find that he has to, my lord, get all these my lord, clearance from the bank before participating in the auction. That it is encumbered on at Kolkata or anything.
But the information has been suppressed. What you say?
No, my lord.
That was not.
What happened, my lord?
Then why are you not filing your counter affidavit?
You file it.
File your counter affidavit.
Yes, I shall file.
You assert it.
Yes.
The other day, perhaps instruction was sought for that it can be sorted out.
Yes.
But
I shall
since you
file
are
it.
contesting the matter, you should file your counter affidavit.
Yes.
Look, issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. You are appearing for all the opposite parties or any notices?
No.
I can remember.
All the appointed.
The land council. Mr. Vibhuti Bhushan Swine, Land Council, appearing for the UCO Bank, accepts notice on behalf of the opposite parties. Do you want any extra copy?
Yes.
All right. Wait to an extra copy of the writ petition be served on the Land Council. Mr. Swine. By tomorrow, you shall have the extra copy. All right. Put up this matter, the week come and say, let it come on 2nd September. In the meantime, you file 2nd September 2024. Counter affidavit is filed in the meantime, serving copy on the Land Council for the petition. Yes.
Item 45.
Item 45, I'm appearing for the petitioner. They have filed the reply also in this case. As always, to your lordship's kind concession, I was only praying a week's time. My friend is assisting me. I need little proper briefing from him. My lord, I'll assist.
It is already there in court record, the counter affidavit.
Yes, everything is there. If just let me just clarify. He is appearing auction purchaser. My learned friend is appearing for the bank. Interim order was passed by the Dishonorable Court. I have learnt in the meanwhile they carried the matter to Honorable Appraise Court. Honorable Appraise Court declined to interfere, saying, "You will pursue here." They will pursue here. Your lordship will decide my fate. This is against an interim order passed by the DRT, asking me to deposit the entire auction amount as a condition precedent and granted stay. Matter was carried in appeal. Appellate court set it aside. That has been challenged in writ petition. The Dishonorable Court has been pleased to protect me. I am only praying for a week's time. If your lordship can, and from 20th week commencing 20th, your lordship may consider.
Now you see, he is a auction purchaser.
Yes.
The auction purchaser, right?
Yes.
So he has already deposited the amount.
No, I have deposited the entire amount.
I also deposit. My lordship, let me submit just and clarify the matter before lordship. My lordship.
No, I am only praying for a deferment today.
Yes, my lordship.
I'll assist your lordship.
It's all right to what he wants that
Only 1 week time.
you have filed the counter affidavit today itself.
No, he has filed long back. There is no dispute about that. He has filed long back, my lord. ଟିକେ briefing ରେ ମୋର personal issues ଥିଲା me. He had come to brief me. This is a personal difficulty. ମୁଁ ସେଇଥିପାଇଁ ପ୍ରେୟାର କରୁଛି ନହେଲେ I will assist your lordship. I have brought everything.
Then let it come on next week.
20th
But status could maybe vacated, my lordship.
20th
My
ରେ
lordship,
ଆପଣ vacate କରିଦେବେ ଯଦି your lordship feels that it's not a meritorious case.
My lordship, let me just submit one line.
Yes.
My lordship, I had gone into the appeal before the DRT Kolkata against the order passed by the DRT. Being the auction purchaser, I was not issued the notice even, and the order was passed without the notice being issued to me. The said fact is that in the DRT's order also. And thereafter, in the appeal, my lordship, the appeals order, my lordship, if my lordship will peruse, that order they have annexed under Annexure 1 in page 20 to 25 of the writ petition. If that order will be perused, my lordship, the order speaks clearly that since from 2022 February, the auction purchaser has been granted the sales certificate, and thereafter since 2 years and more than a period of 2 years, he is running from post to pillar and without delivering of the physical possession. And also, my lordship, on 20th 3rd 2023.
So we may compensate you. If we find that it is not a case for which the expedition is to be entertained, while dismissing, we may impose cost on him and the interest on that amount is to be paid to you. But let him get an opportunity.
Given an opportunity, my lordship, I have no problem with that. But my lordship, my predicament is I am the caveator in this case. I had filed the caveat, my lordship.
We are hearing all of you, but
the status quo was granted without hearing me, my lord.
You were present in court. This is a very unfortunate statement.
I was present, but the court has not recorded that I am the scapegoat. Today also in the cause list it is showing that OP4 not filed the wakalat.
He was present. You were hard.
My lordship will see
you are Mr. S.K. Misra.
Yes, my lordship.
Your name has been reflected on the day when it was
yes, my lord.
Order was passed.
Yes,
so
my lord. I am saying I am present, but that I was not allowed to.
There is a limit when your name is reflected. You said that you are present.
Yes, my lordship.
In
that
the
cause list it is showing that I am not filed the wakalat.
That the order itself reflects that you are hard. We are reading that paragraph. Copies of the writ petition is served on Mr. So and so London Council for the opposite party number so. So you are present. In your presence, the order was passed. How do you say that?
No, I am not saying, my lordship. I am only saying that I am the caveator in this case.
It's all
no
right.
Advance copy was served upon me, and
if you have already waited for 2 years, heaven will not fall if the matter is taken up on 28th. All right. Look, listen. Mr. S.K. Misra, and senior advocate submits that the matter may be taken up a week after for final adjudication. Land counsel for the opposite party number 4 raised objection to such prayer for adjournment put of this matter. Being released dated 20th August 2024, it is made clear that no further adjournment shall be granted. Interim order dated so and so continue till next day.
Grateful man. Grateful man.
Opposite party number 1 and
Mr. S.K. Ghosh Land Council appearing for opposite party bank
1 and 2.
Party number 1. Yes.
Grateful man.
46.
Lordship. Lordship, in the present matter, the petitioner is challenging the selection list for the post of judicial officer for the year 2022, Your Lordship. Lordship, in the present matter, you have received
Post? Judicial
civil judge.
Civil.
Lordship, in the present matter, you have received the counter. You need some time to file a rejoinder, Your Lordship.
No, 2022.
Yes, Your Lordship.
So it is already over. And that must have merged in the out the vacancy is still there.
Lordship, vacancy is still there.
Not qualified at all.
Lordship,
What you are challenging?
Lordship, we're challenging the selection list as well as we're seeking direction for the re-evaluation of my paper.
ଆଉ ଆପଣ candidate ଆଉ appear क्या
No, Your Lordship. After that, she
କାଇଁ?
has it. Your Lordship, this is for the
ତାପରେ
session of
ଦିଥର ହେଇଗଲାଣି 2022 ପରେ 2023 2024
2022 ତ 2023 ରେ
23-24 ରେ ଏବେ ରେଜଲ୍ଟ ବାହାରିଲା ନା ପ୍ରିଲିମିନାରୀ ରେଜଲ୍ଟ
She must not have participated.
Lordship, some time to file rejoiner.
You have received your counter affidavit.
Yes, Your Lordship.
All right. And counsel for the petitioner submits that she has received the counter affidavit and intends to file rejoinder. And the action may be taken off 2 weeks after of this matter. Adjourned progress. Yes.
Obliged, Your Lordship.
Item 47.
Item 47, may I plead, Your Lordship? Your Lordship, the petitioner is a public sector unit and the petitioner has challenged order of the learned Central Administrative Tribunal passed on 3rd January 2024. The impugned order is at Annexure 13, Your Lordship. The operative portion starts at page 104, paragraph 10.
Yes. Who is for the other side? There is only no. Let us see that the opposite parties. No, this Pramod Kumar Mugri. You are for that. So yes, which page you are intending to show us?
Your Lordship, page 104 of Annexure 13, paragraph 10, Your Lordship.
Yeah.
May I place that? It is seen that this bench of the tribunal disposed of TA number 10 and 11 of 2013 on 2014, directing the respondents to consider the pending representation of the applicants for providing employment on compassionate ground within a stipulated period, after observing that the respondents, while considering the case of the applicant, should also take into consideration the financial condition of the family, but as it appears that the respondents rejected the representation without whispering anything about the financial condition of the family, although it is specific case of the applicant that the family is still indigent condition. Further, it is seen that the respondents rejected the case of the applicant by applying the rule prevailing on the date of consideration, which is not in accordance with the law laid down by the Honorable High Court of Orissa, Supra. Further, it is seen that the delay has been weighed much in the mind of the authority concerned, without considering the fact that the applicant and his mother had been vigilant in pursuing the matter, whereas the delay ought not to have been acted as an hindrance. In view of the discussions made above, the irresistible conclusion is that respondents rejected the grievance in an arbitrary manner which cannot pass the litmus test of judicial scrutiny. Accordingly, the impugned order dated 10/10/2014, communicated by letter dated 14/10/2014, is hereby quashed and the matter is remitted back to the authority to consider the case of the applicant for compassionate appointment as per the rules prevailing at the time of death of the employee concerned and taking into account the indigent condition of the family. Your Lordship, for better appreciation of the facts, I have prepared a date chart for your Lordship's reference.
Now, what do you say, that he is not entitled to get compassionate appointment?
Your Lordship, humble submission is that the direction to consider the case of the applicant for compassionate appointment has been made after 32 years. More than 32 years have passed in the meantime from the date of his death of his father, the deceased employee. And the second ground is, your Lordship, that the learned tribunal has directed that the representation of the applicant should be considered as per the rules prevailing at the time of death of the employee. Lordship, the position of law has been now well settled that the rules prevailing at the time of death of the presenting the application should be considered. And in this case, the father of the opposite party number 1 died in 1991. The opposite party number 1 attained majority in the year 1999. And he made a representation before the authority in the year 2007. That is after 16 years of the death of his father. And your lordship, in case of Steel Authority of India, the rule for giving compassionate appointment in cases of natural death have been discontinued since 92, and the prevailing norms provide no such relaxation that if an employee who has died due to natural cause should be considered on for compassionate appointment. These are my primary grounds
the death is natural.
Yes, your lordship.
Huh?
Yes, your lordship.
It is not arising out of in course of employment.
No, your lordship. The death certificate is at annexure 1, your lordship. May I place that? Annexure 1 at page 31. This is to certify that late Manik Deep, son of Thakur Deep, ward boy medical department, aged about 40 years, residing in sector 20 Rourkela, was admitted in the Ispat General Hospital on 11/3/1991 at 5:10 p.m. for the treatment of chronic treatment of septicemia, DIC, and terminal CCF. He has died a natural death, your lordship. He has not succumbed to death during the course of employment.
Okay, what is your scheme prevalent then?
Your lordship, in the year 1982, a scheme was formulated for the employees of Rourkela Steel Plant that compassionate employment would be provided under 3 categories.
Where is that?
That scheme have not been annexed, your lordship, but that is there in the order of the learned tribunal at page 100, your lordship. At page 100, annexure 13, page 100.
Yes.
The system of compassionate appointments was reviewed in a meeting of the advisory committee recently. On the lines of discussions, the system may be operated in future as given below. First priority cases included the employees who die during the course of employment. The second priority case include the employees who suffer from permanent disablement during the course of employment. And in the third priority cases, death for reasons not covered under 1 above, the existing rules will continue. The above will be subject to the following general conditions. The eligible dependents for consideration for such employment would continue to be wife, husband, son.
This page 79 you probably, no?
Your lordship.
Yes.
So, your lordship, the third priority cases in
the existing practice will continue.
Yes, your lordship. And there was 2 conditions to first need to be satisfied to get compassionate employment under natural death. As per the scheme in 1982, the 2 conditions were the minimum that the applicant should be at least matric pass, and the applicant should be a major. The present opposite part number 1 was a minor when the death of his father died. He was 10 years of age.
No, সেটা যে কହୁଛନ୍ତି সেটা সেকেন্ড প্রায়োরিটি কেস কথা কହୁଛନ୍ତି তো?
No, your lordship, third priority cases.
No.
Cases for reasons not covered under 1 above. Second priority cases, your lordship, are the cases where the permanent disablement during the course of employment.
We are concerned with third priority cases.
And in 1991, this scheme was prevalent when the applicant's father died. But there are 2 sets of conditions which needed to be satisfied for applying for compassionate employment under this scheme.
Where is that? Matriculation and etc.
That your lordship has been dealt by the. Actually, your lordship, this case was first dismissed by the learned tribunal. Then a review application was filed. Then this order has been passed by the tribunal. That is dealt at page 60, your lordship. Annexure 8, page 63.
No, the parameters that is fixed, as you said, is not in the scheme itself.
Your lordship, this is an extract from a judgment of Balbir Kaur versus Sel. That in that judgment, only this much portion has been quoted, and but the tribunal has dealt with it.
Since the order, impugned order, indicates that this case is to be considered for compassionate the rules prevailing as on the date of death.
Yes,
we want to see that what was the rule prevailing. at that point of time, and when it changed and to what extent.
Your Lordship.
Right.
That position may I clarify, Your Lordship.
Not clarify, bring the rule, we'll see that. Yeah.
Your Lordship, one, the father of the opposite party died.
Yeah.
Thereafter, wife of the deceased, he applies for professional appointment, Your Lordship. Thereafter, Your Lordship, they didn't consider the application of the wife. Subsequently, the wife filed an application before this Honorable High Court. And this Honorable High Court, taking into the consideration of this Balbir's thing,
That a date chart is necessary. Have you prepared that date chart?
Yes.
Your Lordship, I have
Yes, also, even I also have prepared. So, in that, the Honorable High Court decided that the applicant's, the wife's application may be considered on compassionate appointment. Thereafter, they considered it. While the consideration part, they have already considered the of the wife's after the Honorable High Court, Your Lordship. And they rejected the application on the ground that the wife doesn't have the requisite qualification of matriculation. At that very time, the son was a major and was having a matriculation certificate, Your Lordship. So, representation was given in 2001, in 2005 and 2007. They did not consider, for which they moved an application before the tribunal, and the tribunal in 2014 has passed an order. My Lord, may see page 54 for a moment.
Yes, to consider the representation of the applicants
Yes.
and their prayer.
In 54, it is 55.
Annexure
Your
6.
Lordship. In page 55, the order of the first order of the tribunal in 2014, Your Lordship, where they have given the similar order that it should be considered, because they have not considered the representations and they have delayed the process. So it is not the fault of the applicant who has delayed it. So that is 2014 order of the tribunal. Then they moved before the before the authority rejected on the basis of that 23 years have passed. Your Lordship, my humble submission is that it is not the delay on the part of the applicant, it is the delay on the part of the authority, Your Lordship. And again, they rejected it, for which they moved again an application, the review application and all, and finally.
That let us see that what is that scheme for compassionate appointment
on the date of death.
On the date of death of that father of the petitioner.
But that,
and whether there was any change in that.
Lordship, and as per the 2014 of the tribunal, the representation should be considered as per the prevailing norms. Your Lordship, that part of the order may I place at page. That order starts at page 55, Your Lordship. Annexure 6, Your Lordship, page 55.
All right, but did you consider?
Yes, Your Lordship. The first, what happened in the year 1992, the mother of the
she had not qualified.
She did not qualify.
All right.
Then in the year 1999, the son.
Yes.
And Your Lordship, in the 1999, the son attained majority. In the year 2000,
he filed the certificate.
Mother filed a petition before this honorable court that she should get compassionate appointment. In the year 2001, this honorable court disposed of that matter with a direction that the authority.
It is the Honorable High Court's order is in year 2000, Your Lordship.
Yes,
in 2000,
the Honorable High Court disposed of that petition with a direction that the authority should give an option to the mother to either select family benefit scheme or compassionate scheme.
Yes.
The mother then selected compassionate appointment.
Yes.
Since she did not have the requisite qualification, the authority again pressed her that you should go for family benefit scheme since you don't have the requisite qualification. You are not a metric pass. Then, Your Lordship, the mother of the applicant, the mother of the opposite partner made a representation in 2001. The applicant did not make the representation. And the authority did not consider that because there is a direction from this honorable court that the case of the mother should be considered, not part number 1. And then, Your Lordship, what happened?
Yes. The company is very shrewd in getting the spirit of the order, you know.
55, the order
Yes.
Your Lordship, what is the position?
Yes, they have asked you to consider the application of the mother means only that is to be rejected. All right.
Lordship,
Next.
that is not the case, but the compassionate appointment being not a matter of right, that it
Yes,
the
exactly.
reservation can be kept for more than till attaining majority also.
Yes, sir. Proceed.
And then, your lordship, what happened in 2007, the present opposite part number, he made a and that was then again in 2009 they filed an writ petition. The opposite part number filed a writ petition. The writ petition filed by the mother and writ petition filed by the opposite of party number 1 were both transferred to the tribunal. Then the tribunal on 31/7/2014, tribunal what decided is that to consider the case of opposite party number 1 on the basis of the schemes prevailing on that date. May I place that order, your lordship, at page 56.
In accordance with the exact extant rules and
Extant rules, your
Yeah.
lordship.
Yeah.
Then the authority, as per the direction of the tribunal, considered them as per the extant rules. Consider the application.
What is the consideration?
Your lordship, the consideration, page 57 and 58 is relevant, your lordship. May I place page 57 first?
Yes. What is the outcome
57
of
of
consideration?
Annexure 7.
What is the outcome of the consideration?
They rejected it,
Your lordship, they rejected it, but 2 paragraphs are important, your lordship. At page 57, may I place first?
57 of
57 of Annexure 7. Page 57 at Annexure 7. 57.
Yes.
Yes.
In due deference to the aforesaid order of the, I am reading at the middle portion, your lordship. The paragraph starts with the words in due deference. Your lordship, got.
Yes, yes. After the quoted.
Yes, your lordship. After the order portion was quoted, in due deference to the aforesaid order of the Honorable Central Administrative Tribunal, Cuttack, case of Sri Pramod Kumar Muguri for employment in on compassionate appointment ground was taken up for consideration as per extant rules, relevant scheme and policy of the company. Sri Muguri has not submitted any document or material for consideration of his financial status. They did not submit any material for consideration of their financial status, your lordship, which is impugned in the order passed by the learned tribunal recently. Then, your lordship, may I turn your attention to page 58, your lordship. Page 58, the operative portion starts at the words on perusal of the above. Your lordship, may
Yes,
on perusal
in
of the
April
above,
1990.
following position emerged. In April 1990, it was decided to provide employment on compassionate ground in case of third priority cases, that is natural death. In case the dependent of the deceased employee was having matric qualification, the date of death of Manikdeep was 19/3/1991. Therefore, the request of Srimati Dhiradeep for employment on compassionate ground was not acceded to, as she was not a matriculate. Employment on compassionate ground, which has been allowed under third priority, that is discontinued from 21/11/1992 with the introduction of employees family benefit scheme, and the same has been conferred in terms of tripartite settlement between the management of Rourkela Steel Plant and Rourkela Shramik Sangh, the recognized union, in the presence of Assistant Labour Commissioner, Government of Odisha, Rourkela. So, lordship, on these grounds they have rejected the application. Then they challenged this order on the they challenged this order before the learned tribunal. The learned tribunal dismissed application, and the observations of the learned tribunal start at page 63, your lordship, annexure 8, page 63.
Lordship, after dismissal of the order.
Wait. Yes.
Your lordship, may I please at page 63, paragraph 4.
63, paragraph 4.
Yes, your lordship.
I have heard
the arguments put forward by the learned counsels from both the sides. Your lordship, got it?
Yes.
I have heard the arguments put forward by counsel from both the sides on 30/11/2007 and perused the documents submitted by them. It is stipulated that father of the applicant died from a...
It is undisputed.
Yes, your lordship. The qualifications part and date of death, those things are undisputed. They did not raise any objection before the learned tribunal also.
Please.
Yes, your lordship. And it is undisputed that the father of applicant died from a complaint of septicemia on 19/3/1991. The applicant's mother did not have the requisite qualification for appointment ground. The applicant himself was only 10 years around the 10 years of age at the time of death of his father. The crucial issue to be decided in the present OA is whether his claim for compassionate appointment persists even after 26 years of the death of applicant's father, even though the applicant became a major in 1999 and had acquired qualifications of HSC at that time. Then the rule prevailing at that time was quoted, Your Lordship. The compassionate appointment in RSP is considered under Policy Circular number 1007 2011, which provides for relief or benefit to the dependent family members of the employees in cases of death, permanent total disablement, and medical invalidation. The procedure prescribed in the said circular is as follows. Your Lordship, the relevant portion is at page 65 of that rule. Page 65 under the heading coverage. The next page, Your Lordship. The cases under the heading coverage, fourth paragraph. The cases of death in harness shall not be considered another for dealing with appointment on compassionate cases. Then, Your Lordship, paragraph 7. It is quite obvious that as per the rule being followed in RSP, compassionate appointment is not permitted for the ward of the employees who die a natural death. On that ground, the applicant's claim for compassionate appointment is not tenable. Then, Your Lordship, the question of delay has been considered at paragraph 9. Your Lordship, page 67. May I place that paragraph? Case, the applicant has approached this tribunal in the year 2014 after a gap of 23 years from the death of his father. It is quite obvious that the immediate need of family has already been met, and compassionate appointment in the present case is not to be considered as an immediate succor to the bereaved family. Consideration of compassionate appointment at this belated stage will be a travesty of the object of the scheme and also violative of the right of equal opportunity among the meritorious candidates who will compete for the jobs available in RSP. Your Lordship, this was the order passed by the Learned Tribunal in 2007. Your Lordship, it was recalled, it was reheard, and in the 2022, the tribunal, without considering the question of delay, had passed an order relying upon a case of Balbir Kaur that compassionate their application for compassionate appointment should be considered, and the policy which is prevailing at the time when death occurred should be taken into consideration. Your Lordship, may I rely upon some judgments where it has been held?
So the last judgment that has come by Honorable Justice M.R. Saha after 30 years.
Yes, Your Lordship.
Yes.
In 2022, and Your Lordship, in both two judgments are there, Lordship. In the year 2000, the Supreme Court has held that period of gaining majority, that is also to be considered as delay, since the object of compassionate appointment is that it is a scheme which provides immediate relief to the family. Now, it is not a matter of right. It is an exception to Article 14 and 16, and that period of gaining majority is also considered to be as delay, Your Lordship. May I place those judgments, Your Lordship?
Your Lordship, the chronological after this order was passed, this order has been reviewed, Your Lordship.
Since let him,
Yes, Your Lordship.
let him finish, then we will hear you. Yes.
Lordship, in 2022 SCC Online, Justice must have asked the judgment that compassionate appointment cannot be considered after a period of more than 30 years, or 24 years was the period in that case, Your Lordship.
Which paragraph?
Your Lordship, those judgments I have placed. These judgments, say that.
And please take your seat.
Yes.
When your turn comes, you will argue the matter. We will hear you. Not yes.
Your Lordship, at paragraph 19.
This is 2022 SCC Online.
SC 1331.
Yes.
Paragraph 19, Your Lordship.
Yes.
Your Lordship got. May I please?
Yes, yes.
Applying the law laid down by this court in the decisions to the facts of the case on hand, and considering the observations made herein above, and the object and purpose for which the appointment on compassionate ground is provided, the respondent shall not be entitled to the appointment on compassionate ground on the death of her father, who died in the year 1995 after a period of 24 years. In this case, it is more than 30 years already. After a period of 24 years from the death of deceased employee, the respondent shall not be entitled to the appointment on compassionate ground if such an appointment is made now and or after a period of 14 or 24 years, the same shall be against the object for which the appointment on compassionate ground is provided. Under the circumstances, both the learned single judge as well as the division bench of the High Court have committed a serious error in directing the appellants to reconsider the case of the respondent for appointment on compassionate ground. The impugned judgment and order passed by the High Court is unsustainable. Then your Lordship may place reliance on a judgment reported in 2000, Volume 7 SCC.
What is this decision you placed, Malaya Nanda?
Your Lordship, that I
Yes.
I have given that, Lordship.
Okay, better. Yes.
Your Lordship, this judgment 2007 SCC, page 192. May I draw your attention to paragraph 3, Your Lordship? May I place, Your Lordship?
Yes.
We are unable to agree with the submissions of learned senior counsel for the petitioner. This court has held in a number of cases that compassionate appointment is intended to enable the family of the deceased employee to tide over sudden crisis resulting due to death of the bread earner who had left the family in penury and without any means of livelihood. In fact, such a view has been expressed in the very decision cited by the petitioner in direct versus Pushpendra Kumar. It is also significant to notice that on the date when the first application was made by the petitioner on 2/6/1988, the petitioner was a minor and was not eligible for appointment. This is considered by the petitioner. There cannot be reservation of a vacancy till such time as the petitioner becomes a major after a number of years, unless there are some specific provisions. The very basis of compassionate appointment is to see that the family gets immediate relief, Your Lordship. So this judgment deals with the fact that even from 1991 till 1998, that delay also cannot be considered while dealing with cases of compassionate appointment. In another judgment of the Honorable Supreme Court, reported in 2011-13 SCC, this the same thing has been dealt with by Your Lordship. That's
coming within 2 minutes.
Yes.
Maybe excuse my name. Excuse my name. Item 30 may be taken tomorrow. Okay.
Lordship. May I pleasure.
Just come to that this court's order dated 5/7/2000. Annexure 3.
Yes, sir.
Please read paragraph number 2.
The petitioner's prayer for compassionate appointment was rejected on the ground that in case of natural death, compassionate appointment cannot be given in view of the tripartite agreement of 1989. In view of the judgment of the Supreme Court in Balbi's case, the Steel Authority of India is required to consider the petitioner's application for compassionate appointment in accordance with the rules for compassionate appointment applicable to the case of the petitioner. However, the petitioner will be at liberty to exercise option whether she will continue her prayer for compassionate appointment or wants to take the alternative family benefit scheme. This court believes and expects that an organization like Steel Authority of India will consider the petitioner's application with required compassion and sympathy. The final decision of the petitioner's application will be taken within a period of 2 months from date of communication of this order. The writ petition is allowed to
This
the
order was passed in 2000.
Yes, Your
We
Lordship.
are in
2000. This
we are in
2024, Your Lordship.
So this is the way you are dealing with the compassion and sympathy.
Your Lordship, the petition other of the
All right. Yes.
OP number 1.
May I please, Your Lordship? Your Lordship, first I'll cite the chronological thing, Your
Yes.
Lordship. In chronological way, after the death happened in 1991.
Your date chart, this date chart.
I have a okay. Lordship, I'll provide Your Lordship the date chart. I don't have, I haven't made for myself. I'll provide it, Your Lordship.
You want it another day?
I can chart. I can
Provide your date chart. We'll hear this matter tomorrow. Okay.
Yes, Your Lordship.
Your Lordship, may I submit one last thing, Your Lordship?
Yes, you have already given the citation.
Your Lordship, after this direction was
All
passed
right,
by
all right.
this
We have,
honorable
I
court,
have gone through it. Yes.
uh,
Madam, tomorrow you come ready.
Yes, Your Lordship.
Yes.
Item 38.
Lordship, please, my lord, I am appearing virtually, Your Lordships. This is that termination of lease matter, Your Lordships heard last week. The opposite party, my lords, have received a counter on Monday. I am filing my rejoinder reply today, Your Lordships. So it may be taken up for final hearing any date next week. Court date, my lords.
You have received the copy of the counter affidavit?
Yes, yes, Your Lordships. On Monday I have received. Today I am filing the rejoinder reply.
No, they have filed it.
Counter, upon file.
Yeah, filed.
Opposite.
I'm appearing for the OSF's lawsuit. Opposite party.
So Amitabh Das has filed.
Yes, Your Lordship.
On behalf of opposite party number 2.
OSFC.
All the opposite lawsuit.
All right. Mr. Das, do you intend to file any rejoinder to this counter?
I am filing it today, Your Lordships.
Okay.
I am filing it today. In course of day, my lords, it will be filed.
counter affidavit has been filed by the land counsel for the opposite party number 2. He has already been served on the land counsel for the petitioner. Mr. Das, land counsel appearing for the petitioner, submits that during course of the day he filed the rejoiner affidavit. Let the copy of the rejoiner affidavit be served on the land counsel for the opposite party. Put up this matter. To go through it, let us take it 2077 August 25.
Grateful.
Item 39.
May please, your lords. In this case, my last occasion, Honorable Court directed to produce the assessment of the award amount by the opposite parties. My lord.
Their representation is pending in Annex 5 now. But it's 28/4/2024. You have not got any response from the
No.
Annex 5 is to be disposed of 3 months' time and order is to be communicated. Yes.
Item 50.
May I please, your lordship? Petitioner before this application may challenge the order of the Honorable K at 50.
Appearing for Mr. Padi, you are there?
Yes, my lord.
Yes, my lord. I mean, these are the document.
This,
Yes, my lord. I have approached the Honorable Court challenging the order of the 4/4/2024 passed by the Honorable K at, my lord.
that order is Annex 8.
Annex 8, my lord.
Okay.
My case is, my lord, the petition as lordship will.
What was your prayer before the
my prayer to grant me notional promotion as has been granted to the criminal plus persons from the high skill, from the semi skill to high skill, as well as some other semi skill to skill and high skill, my lord. My lordship kindly in Annex 2, my lord. Page 15.
No, we'll go to that. Please come to the reason part assigned by the Land and Trial
Tribunal has assigned that.
Number 7.
Yes, my lord.
Page 24.
Yes, my lord.
Then we'll go to the
My lord. It is seen from records that the applicant was initially appointed as DB worker, danger building worker, by the order dated 1990 and passed the trade test for fitter instrument. He was redesignated as fitter instrument, semi-skilled, by the order dated 13/12/1991. Seen from the shell order that 13/12/1991 that Sri M. Budek and few others having qualified were redesignated as fitter general. It is also seen that the seniority of the employees of different trades are being maintained separately. The applicants in OA number 7 and 8 of 2011, that is Sri Jagdish Chandra Subhidrai and Sri Navagan Behera, respectively, belongs to fitter general trade. Similarly, the applicants in OA number 610 of 2014, that is Sri Krupasindhu Nanda, Sri Surendra Behera and Sri Bonwal Bhoi, also belong to fitter general trade. Sri M. Budek also belongs to fitter general trade. Sri M. Budek, who was junior to Sri Jagdish Chandra Subhidrai, Sri Navagan Behera, Sri Krupasindhu Nanda, Sri Surendra Behera, and Sri Bonwal Bhoi, was given promotion. The applicants therein in OA number 7 and 8 of 2011 and 6 and 10 of 2014 were granted the benefit of fixation of pay nationally as well as in debital seniority. But in the instant case, the applicant belongs to fitter instrument trade. Therefore, there is no question of parity and the decision relied on by the Land Council for the applicant is not applicable to these present facts and circumstances of this case. It is seen from the letter day 19/9/2017 that the respondents have rejected the case of the applicant on the same ground that he belongs to different trade than Sri M. Budek. This tribunal does not find any legality on the part of the respondent in the claim of the applicant guaranteeing interference.
So, your contention, come to the contention, paragraph 6.
Madam,
What was your
main contention of the learned counsel for the applicant is that in similar cases, for like the applicant, what has been given in that is that there. When Budek can approach the tribunal when on 8 and this annual tribunal has disposed of the same, had ordered so and so, granting the relief to the applicant therein. It is further stand that the applicant in number so and so, but also granted benefit based on order of this tribunal and so and so. Therefore, contend that since the applicant was similar to Budek, when initially approved as DBW, he should be given the benefits as extended to the applicants in the OA number 7 and 8 up to 11 and 16. That is.
Contention was that was torn down because you belong to a different trade.
Madam.
Okay. You belong to fitter instrument trade, right? Fitter instrument
general.
They belong to
fitter general. I belong to fitter instrument trade.
Okay.
For that reason, honorable tribunal held that we belong to different trades, therefore we can be equipped with them. Yes. You will also find while disposing of the small, you will also the honorable court did not consider my application, my specific case that was not discussed also. Was 15 also may kind of say that was before this tribunal also. Annexure 2. All the person here, I am at page at serial number 12. Kumud Ranjan Ponda. And all other person that is, they are all belong to me.
Trade.
Well, all are belong to danger building trade. You will surely find.
No, danger building not. Fitter is trade. Danger building you have already covered.
All are covered under SEM. They are selected under the DB worker. All are in semi-skilled. Thereafter, they are redesignated to different trade.
Yes. No. Initially, you were semi-skilled. Thereafter, fitter instrument.
Semi-skilled in danger building work.
Yes.
Thereafter, they are redesignated to different trade.
Yes. They have been promoted.
No, promoted then in semi-skilled. In same trade, what different trade are different trade under semi-skilled.
No, under Annexure 2, what is the difference? What do you want to show by this?
Below you have to kindly see. Last. The seniority of the above employees in the redesignated post used to be reckoned from the date of holding the post of danger building workers. That is semi-skilled. Their promotion will be calculated from the date they hold semi-skilled post in the danger building trade mirror. There is no discrimination whether in their seniority will be counted. Here,
according to you, the seniority cannot be on the basis of different trade. But under the danger building work.
My lord. In that case, I am placed over the mirror. I have also filed a calculated that is comparative sheet at page 19.
No, this is all that you are mentioning under Annexure 2 or some any other rule is applicable to yours. What is the manner of promotion? What is the scheme for promotion? And who will be eligible, how it is to be taken? What is that?
That is not neither the
no, there must be some guideline basing on which this promotion would have been there. No, how many years the promotion will be there? Who will be taken for promotion, for eligibility of the promotion? Who will be taken for to the consideration zone?
That is I have reflected in my representation, that is page 19, page 6.
No, randomly is the authority going for promotion?
They are doing the promotion. That is my case.
There must be a scheme for a promotion. No.
ଏଇ ଯୋଉ ଲୋକମାନଙ୍କୁ କହିଲେ ଆପଣ Annexure 2 ରେ
ଆଜ୍ଞା
ଏମାନଙ୍କୁ ଦେଖାହେଇଛି ଜେନେରାଲ ବୋଲି ଯୋଉମାନେ କି ଆପଣଙ୍କ ତଳେ ଅଛନ୍ତି କହୁଛନ୍ତି you are
at serial 12.
Please, no, your number is item number
12.
Serial number 12. It is mentioned that you are fitter / instrument and semi-skilled, and it is mentioned that fitter, general, mechanical, semi-skilled. Okay. So now if you come to the order of the learned Central Administrative Tribunal, you will find in paragraph number 7, page 24, which you are listing. Just once again, just place few lines. Page 24.
Yes, sir.
Please place paragraph 7.
It is from the records that the applicant was appointed as DB worker and by the order dated 28/8/90 and passed the trade test for fitter instrument. Was used as fitter instrument, semi-skilled. By the order dated 13/12/1991.
That is annexure 2.
That is understood. That
Yes.
is which I placed.
Yes, sir. Now you see. It is seen.
It is seen from the said order that the said order dated 13/12/1991 that Sri M. Budek and few others having qualified were redesignated as fitter general.
Right. Yes.
It is also seen that the seniority of the employees of different trades are being maintained separately. The applicants in row number 7 and 8 of
in that particular trade, this M. Budek was senior in that particular trade. Is a fitter oblique general. You are senior in that particular
instrument.
In danger building worker, semi-skilled, I was senior.
No, that is why the query is made that what is the basis on which it is said that a category is maintained. Seniority of the category is maintained. According to the, it is seen from the said order that M. Budek, it is also seen that the seniority of the employees of different trades are being maintained separately.
That is their standard.
Where is that? Have they filed it?
No, they have not filed anything.
They have not filed. Then how the court could come to know? Where from the court saw? It is also
on the submission of the council of the.
This is actually the crux of the matter. Because what you are showing that this is a list and the seniority is to be maintained like this, and I am senior too because my number is 12, their number is 22, etc. But they the stand which has been taken by the other side is reflected in paragraph number 7.
Yes, my
it is stated that
they belong to different
the
trade.
seniority of the employees of different trades are being maintained separately. So if that is the case, how do you meet it? And
may I pray, my lord?
Reflected by the learned Senate tribunal that must in the counter they must have taken averment. Otherwise, how will you vote it? This copy is not there. Now I can say, but unless until it is not averment is come not.
In the before the Central Administrative Tribunal, did the other side file the counter affidavit? Where is that counter affidavit? Maybe that it have been indicated in that counter affidavit that why this you are not entitled to get that. Why got it? All these things have you got it with you?
Yes, I have got.
You should file. That is very important.
This is not only your original application but also the counter affidavit.
Yes.
Because here we cannot give any scope in a writ petition where the order of this to file the counter affidavit, because whatever material is there on that basis it is to be
considered,
reviews to be made whether the order is correct or not.
And you are selling on the basis of that the counter is something and the consideration has been made in a different way. So unless the counter, how can we know?
Because in paragraph number 2, page 23, you just come to that order. Page 23 come.
You may not. Yes, ma'am. The respondent in the counter entirely affirmed that where needs to be dismissed on the ground of delay, lectures and due to non-joining parties. It is submitted that Sri M. Budek was re-exempted to semi-skilled grade of fitter general trade and applicant to semi-skilled grade of fitter instrument. It is submitted that since the applicant belongs from the trade of fitter instrument, he cannot compare this to employees from other trades. It is submitted that similarly placed employees who were granted national promotion also belongs to semi-skilled grade of fitter general trade, and the applicant cannot claim parity. It is submitted that the applicant had repented against the draft seniority list published on so-and-so, had this repented so-and-so, and the same has been disposed of, had already so-and-so.
So what is your rejoinder? Just the next paragraph.
The applicant has filed rejoinder wherein it is submitted that applicant as well as M. Budek faced interview and selected for the post of fitter general and were also given appointment in semi-skilled grade of DBW and subsequently who were redesignated as fitter general oblique fitter instrument. It is also submitted that similarly placed employees had approached this honorable so and so
ଏଇଟା ଆପଣ ଏଇଟାକୁ ଯୋଉ ରିଜେଣ୍ଡରରେ କହିଲେ ଏଇଟା ଆମେ ଯଦି ଦେଖିବୁ annexure 2 ଯୋଉଟାକୁ ଆପଣ ରିଲାଏ
ଆଜ୍ଞା ଆଜ୍ଞା
କରୁଛନ୍ତି ସେ କ୍ଲିୟରଲି ଡିଫରେଣ୍ଟ ଥିଙ୍ଗ ମାନେ ଆପଣଙ୍କର ନମ୍ବର ସିରିଏଲ ନମ୍ବର 12 annexure 2 page 15
yes
indicates that you are fitter instrument and they are fitter general ର ଯୋଉମାନେ ଅଛନ୍ତି what they say they belong to a
different trade
different grade so that is
that is but in this particular annexure mirror you will also read on the below it has been stated that it should be counted from the they hold a semi-skilled post as danger building worker that in the second column all are appointed as danger building worker
ଏଇଟା ହଉଛି 13/12 କେବେକାର 13/91
ଆଜ୍ଞା 13/91
ତାପରେ କିଛି ଚେଞ୍ଜ ହେଇଥିବ ଯଦି ଯେ ନାହିଁ ପ୍ରତ୍ୟେକ ଗ୍ରେଡ ପାଇଁ
has to be taken separately.
ସେଟାକୁ ହୁଏତ ସେମାନେ Mr. Padi, what is your instruction on this?
My lord, I don't have the first time I have received the copy on 30th. I sought for instruction. Lordship, keep it to some other day. I will get with all the copy of the counter which was filed before the Land Central Tribunal, as well as it is better to also file an application which is filed before the tribunal. Then it is
Please look
clear
at
for us to.
Mr. Padi, please look at Annexure 2.
Yes,
Annexure 2 is at page 15.
yes, my lord.
In that list, the name of the petitioner finds place in serial number 12.
Yes, the P115 fitter stroke instrument.
Right. And the persons who have given the promotion, they are not in. They are in, of course, a Peter General. Those persons have been given promotion, right? But what he says that in the down below it is mentioned that the seniority of the above employees in the redesignated post is to be reckoned from the date of holding of the post of danger building worker bracket semi-skilled. So they all come into that danger building worker semi-skilled, but you have not stated here that the seniority will be counted on the basis of their grade. Whether subsequently that has come for which that on the basis of the trade wise you are to give the seniority.
Is it there or not? Kindly that
So
you
that
find.
instruction you take, please.
Yes.
Otherwise, he just points out from the that 3 lines in that annexure to last 3 lines and says that if I am senior as per that and the seniority is to be considered as per this letter, then why I will be deprived and why my juniors will be promoted. That is his stand.
Yes. At that part, I have taken instruction.
Subsequently, you have changed that no, the grade wise it is to be the seniority is to be dealt with. Then certainly the tribunal is correct.
Putting will be different.
That is, of course, your stand in the counter affidavit also.
Maybe this copy not with me.
Just so we'll take up this matter a week after you get ready.
Yes.
The Mr. Pradeep Kumar Kuntia, Land Counsel, appearing for the petitioner, and Mr. Pari, and name of
Me along with me, Mr. B.K. Padi, Virendra Kumar Padi.
Virendra Kumar Padi, and Central Government Council. The Mr. Padi submits that he may be given some time to obtain the original application, the counter affidavit file, and also to take instruction in the matter. And the matter may be taken up a week after. This matter we commence from 20th August 2020.
My lord is fixing to.
20 तारीख ହେଲା ପରା ରହିଲା.
Can it be 23rd? Or 22 or 23rd?
ଆସିପାରିବନି ସେ 20, 21, 22 ର ଲିଷ୍ଟ ରେ ଥିବ ଏଟା.
ହଁ ଠିକ ଅଛି ଆଜ୍ଞା.
And the name of the land council be reflected in the court list also. Yeah. Good.
Lordships, this is a matter
Your item
32. I think that was passed over yesterday, Your Lordships. Your Lordship, this is a matter concerning the class 4 employees who were initially engaged in contractual way to the post of court managers. Your Lordships are aware that we had this court manager post. We have it in a high courts and various district courts. So initially those posts were also contractual. And then the High Court wrote to the concerned department that we need also class 4 employees, and they agreed up. And what happened is, as these contractual appointments were continuing, they said that we will not extend the contractual appointment of these class 4 employees. Then the matter was carried to the High Court on its judicial side, and then the bench said that no, this has to continue as long as the court manager posts are also continuing. And they continued as such. Subsequently, Your Lordships, the High Court at the judicial, at the administrative side came up with these rules, and the court manager posts have been made permanent. And in fact, appointments have also been made. All the posts have not been filled up throughout the district. So then the question arose, but these class 4 employees remain as such as contractual only, and they have been continuing. So 2023, they said, no, the department said, I'm going to only extend for those where the court actually an incumbent is there, and for the rest of the post, we will not extend it. But Your Lordships, the logic which the High Court gave is at Annexure 10, page 37. This order dated 29/4/2023, Annexure 10, page 37. If Your Lordships permit, I will place the whole order.
Yes.
With reference to the caption subject, I am to say that 32 class 4 employees were engaged in contractual basis to assist the court managers in their office work and are rendering their services till date. May it be noted that pursuant to Rule 6 of the Odisha Senior Court Manager and Court Manager of the High Court and District Court Methods of Recruitment Condition Service 2020-20, 11 candidates were selected for the post of Court Manager on regular basis, out of which 10 joined. Nonetheless, the office of the rest of the court managers are functioning in different district headquarters of the state. So now a complete office has come. It is also way to mention that all offices of the court manager in the state are not only functioning, but they are carrying out the assignment as per the instruction of the registry of the High Court as well as District Court. The Honorable Court has also taken steps to fill up the vacant posts of the court managers. It is not out of place to mention that the Honorable High Court in WPC so-and-so in order dated so-and-so had observed that mere digital help will not be enough unless class 4 employees to assist the court managers. Therefore, I direct to request you to necessary steps to expedite further extension of the tenure of the re-engagement of class 4 attached to the court managers with effect from 18 January 2023. An order therefore may be communicated to the court soon. But Your Lordships, what they did is, they did not do so, and they passed the impugn order, which is at page 59, which of course has been stayed by this court. Page 59. They said, inviting reference to the letter dated so and so and so, the above notice subject, I am direct to say that in obedience of the court order dated so and so, attached to the court manager states are to be availed as per the prevailing norms when the post of court managers are to be filled up. So they said that only those where the court manager is actually there, we will allow the extension, rest will not. But at this stage, Your Lordships, we came and we stayed the matter, stayed this order. So the court manager, so the class 4 employees, whoever they are, wherever throughout Odisha, they are still continuing. But so therefore, it means that if we are rendering our services, we should be paid salary. Even though this order is in place, no salary is being paid, but we are working, Your Lordships. So today I am actually pressing also for the salary to that effect. I have a flag B. At flag B, we have an IA also. So therefore, Your Lordship, unfortunately, in this
So they are not getting their wages.
Not getting the wages, but they are continuing, Your Lordships. At flag B, even that order I have annexed. That also is, of course, there in the order sheet.
No, after the order of stay, anything has been passed from the side of government? No.
No, they are not doing. They are not giving any money. No salary is being
Stay
disbursed.
order was passed on?
35/2023.
That is in I it has been annexed as an issued one.
Yes.
So, Mr. Mishra, when this order was passed, whether you were paying them or not to the court managers?
Class 4 of the court managers. Class 4.
Class 4.
They were being paid regularly. They were being paid regularly. So after
what
this stay, why?
status quo order was passed, why their payment has been stopped?
There is no reason payment should be stopped.
No,
Let me take instruction.
in the interim application, specific averment has been taken. Where is that averment, Mr. Dotto?
Reply be copy service.
They have stated though they are working continuously since January, they are not getting their pay along with.
But then it has also happened in such cases, since it is being extended from time to time,
6 months.
the money is being paid from the contingency also. For the daily was there, contractual daily was worker. So from the contingency also the district judges, they used to pay.
I'll find out.
Kindly see.
But actually, I was requesting my give a copy of this.
We'll give now. We give in, but we'll give additional. If
IA copy.
more they look if it's been misplaced, we'll give another one.
All right.
The receipt is there.
IA number so and so. There is an application for a direction to the opposite party for payment of salary in the pending arrears salaries of the petitioners. Averment has been taken in paragraph number 5 that even though the order dated 30/5/2023 passed by this court in this case has been communicated to the opposite party, also continuing in their respective places in the post of class 4 employees, but the state has not paid their salaries and they are working continuously since January. They are not getting their pay along with the other service benefits. The Land Council for the state, the Land Council for the petitioner handed over a copy of the interim application. The Land Council for the state info. You file it, copy, Mr. Mishra.
We'll give it.
He seeks some time to obtain instruction in the matter. Aware of you phone.
I will only provide the instruction,
What has been hinted out to you that they used to pay from the contingency fund. So that kind of arrangement can be made.
And in any event, if this all grants entry mode, nothing.
No, normally that is how we get a instruction from the government to make the payment from the contingency, which will be reimbursed by the government. That is happening. They should not go without wages, no?
So then let it come on 20th, huh? You are getting sufficient time. Please this matter on 20th. Yes.
Lordship, item number 29 on weekly list.
Yes, just a minute. Yes, madam, which item you are mentioning?
It's item number 29 in weekly list, Lordship, and I am appearing on behalf of arguing counsel, Mr. Matthew. Actually, suddenly he down with fever and with bad cough, so he is not able to available today before the honorable court. So, my Lordship, is just a humble request to list the matter for tomorrow, or it's on next week of Tuesday or Wednesday, subject to the Lordship convenience.
Some mention was made perhaps yesterday on Monday to adjourn this matter, and today. You want adjournment till next week or what?
Lordship, it's convenience as per the Lordship, because it can be list for tomorrow or the next week of the weekly list, Tuesday or Wednesday.
This is for the entire week, so there is no problem. It can be called tomorrow if is well. It can be taken up tomorrow. There is no problem. But
Lordship, very well, Lordship. We are taken up for tomorrow. No problem for it.
In fact, on Tuesday, my lord, initially started, he was mentioning for the matter to be taken up.
Okay.
My lord, because Mr. Hawk was not there, so it was only, my lord, because the court also requested Mr. Matthews to intimate Mr. Hawk, and he must have done.
Okay. So he is present today. So,
my lord, I am on behalf of OP number 2, Union Public Service Commission.
it's all right. Today he is not well. His submission is just made. So it can be taken up tomorrow or next week. You say, all of you say that, then we can fix it.
Next week, my lord, next week.
Yes.
Interim order to be extended. Then.
Interim order is to be extended, of course. A submission is made on behalf of Mr. Matthew, Sunil J. Matthew, that is not well, and the matter will be taken up next week. Mr. Yaul Park, appearing for the opposite party number 2, na?
2, my lord, Union Public Service Commission.
Is this matter next week, that is 12th of August 20. Your matter in WPC number 16303. There is an interim order.
303 of the 2022.
32 interim order to continue. So, yes. It to come along with WPC. Mrs. Rotha, your case is also this matter. Analog this WPC number 16303 or.
Brief has been transferred.
Oh, I see.
In fact, let our names be deleted.
Okay.
Hello, 302 and 303. That is the analogous hearing.
Let me inform you and now senior advocate submit that since the brief has already been transferred, our name and the name of our associate may not be reflected in the call. So this matter next week, the names of Mrs. Pamirota and our associates will not be reflected in the call. AWG item number 16302. It is to come along with 303 16. That's only matter. That's all. That's all. And in both the matter, the name of counsel shall not be reflected. Hai na? Okay. Yes.
My lord, item 34, my lord.
Lordship, it's listed for next week tomorrow.
12th it will come, madam. It will be
Next
there
week.
12 to 14 in that cause list.
Week commencing for 12.
Week commencing from 12th hour.
Very well, Lordship. Highly obliged, Lordship.
Item 34, may I plead, my lord? It's a matter related to the rehabilitation assistance scheme, my lord. That the father of the petitioner, while working as a peon in the establishment of this honorable court, he died in the year 2018. Thereafter, the petitioner made her application on 21st January 2019, but that was rejected only on the ground that the petitioner was found to be underage, my lord, as per the High Court rules. After attaining the age of 21, the petitioner once again applied again, but that was also rejected under Annexure 4, my lord, citing the reason that the
So notice was issued earlier.
notice was issued on yesterday.
Who is the other side? You are appearing. So, do you intend to file any counter to this, or you have already filed counter? Yes, it is
Counter is
already
already
filed.
filed.
It is already filed.
Okay.
Yesterday, my lord was asking the decisions of the model in the city. I've read that.
Now that is already with us, right?
What is the ratio laid down in that case?
Ratio was laid down that the rules governing at the time of the death of the deceased employee will be applicable regarding consideration of the application, my lord, not the rules governing at
The
the time.
amended rules. Now that the 2020 amended rules have come,
Yes.
and according to that, the person can only be posted in Group D, Class 4.
I do not dispute the have rejected, citing that as the new rules have come into force, that's why you are not eligible as per the new rules.
Yeah. Because there are various parameters.
Yes,
If you
ma'am.
do not come in the category,
You have to score more than
points,
44
points
points
or something like that.
Yes, ma'am.
So if you are coming within the new rule, then you do not meet the points.
My case is that I'm not eligible under the new rule. My case is to be considered under the old rules because at the time of the death of my father, the rules was governing the field.
Just read that relevant paragraph.
And paragraph 7, my lord.
Yeah.
Page 4 of the judgment. Thus, from the aforesaid, it can be seen that there was no fault and or delay and or negligence on the part of the appellant at all. He was fulfilling all the conditions for appointment on compassionate grounds under the 1990 rules. For no reason, his application was kept pending and or no order was passed on ground.
It is not a case of this.
But it was summarized in the later on.
Already. Please, sir.
On one ground or the other. Therefore, when there was no fault or delay on the part of the appellant and all throughout there was delay on the part of the department authorities, the appellant should not be made to suffer. Not appointing the appellant under the 1990 rules would giving a premium to the delay and or inaction on the part of the department authorities. There was an absolute carelessness on the part of the department authorities. The facts are conspicuous and manifest the grave delay in entertaining the application submitted by the appellant in seeking employment which is indisputably attributable to the department authorities. In fact, the appellant has been deprived of seeking compassionate appointment which he has otherwise entitled under the 1990 rules. The appellant has become a victim of the delay and or inaction on the part of the department authorities, which may be deliberate or for reasons best known to the authorities concerned. Therefore, in the peculiar facts and circumstances of the case, keeping the larger question open and aside, as observed herein above, we are of the opinion that the appellant herein shall not be denied appointment under the 1990 rules. Thereafter, my lord, paragraph 9, my lord. Before parting with the present order, we are constrained to observe that, considering the object and purpose on compassionate grounds, that is, family of a deceased employee may be placed in a position of a financial hardship upon the untimely death of the employee while in service, and the basis or policy is immediacy in rendering of financial assistance to the family of the deceased consequent upon his untimely death. This is important one. The authorities must consider and decide such applications for appointment on compassionate grounds as per the policy prevalent at the earliest, but not beyond a period 6 months from the date of submission of such completed applications.
So here,
thereafter, my lord, if the object and purpose of the appointment on compassionate grounds are envisaged under the relevant policies or the rules have to be achieved, then it is just unnecessary that such applications are considered or not in a tardy way. We have come across cases where, for nearly 2 decades, the controversy regarding the application made for compassionate appointment is not resolved. This consequently leads to the frustration of the very policy of granting compassionate appointment on the death of the employee while in service. We have, therefore, directed that such applications must be considered at an earliest point of time. The consideration must be fair, reasonable, and based on the relevant consideration. The application cannot be rejected on the basis of frivolous and for reasons extraneous to the facts of the case.
No, we are asking you a question. When your father died, at that point of time, this 1990 rule was prevalent, right? But at that point of time, no application came.
There was an application that was rejected under Annex 3, my lord. that there was an application and that was rejected under Annex 3, my lord, page 11.
Who asked for prayed for compassionate appointment?
The daughter of the deceased employee.
Okay.
May I place that Annex 3, my lord?
Yes, yes, please.
Year and dated 21st January
When
2009.
your father died?
My father died on 19/9/2018.
19/9/2018. By that time, which rule was prevalent?
1990.
1990 rule was prevalent. Asha. Yes, sir. Then,
I applied on 21st January 2019.
yeah.
Your application dated 21st January 2019 for appointment to Group D post in the Odisha High Court establishment under Rehabilitation Assistance Scheme after the premature death of your father has not been considered as you are found underage for the said appointment. You are therefore directed to apply afresh for appointment under Rehabilitation Assistance Scheme within 1 year from the date of your attending.
So that was one of the criteria. That must be 21 years.
But as per the OCS rules, 18 years was. As
we have our own rules.
Yes.
Then what happened?
Then thereafter, after attaining the age of 21, I again applied.
No. You again applied. Okay.
And that was rejected under Annexer 4, which is impugned herein. Page 12.
Page 12.
After careful consideration.
Page 12.
May I place?
Just a minute.
New Act. After careful consideration of your application for appointment under the Rehabilitation Assistance Scheme, the authority have been pleased to reject the same as you were found ineligible for such appointment in the court's establishment pursuant to the notification dated such and such dated 17/2/2020, which is the commencement of the OCSRA Amendment Rules 2020, my lord. Issued by the government.
What is that new?
That is, they have annexed in their counter affidavit also.
Okay, let us see that.
That my lord will find it page 6 of my.
These rules may be called so and so. Okay, and if we come to the last of that rule, then that is in who paragraph relevant?
So kindly come to page 10.
Page 10.
Page 10. Rule 6 sub rule 9.
Rule 6A. All pending cases. Yes. As on the date of publication, so and so. So this rule, that means when you applied in 2018.
2020.
Second time के भी apply करी date.
2020 रे.
Date तक होना थी application.
Yes, my lord. 24th August 2020.
24.
2020.
2020. এটা কেবে আসলো February.
17 to 20.
So, Mr. Counsel, unless this particular 6.9 which has been pointed out, that is challenged.
It is challenged.
Like this.
It was challenged, my lord, in the case of Suchitra permits by way of a rejoiner.
Yes,
I will
yes.
place the judgments of those cases.
Yes,
in the case of Suchitra Bola and Bindusagar Samudra. And recently, by Honorable Single Judge in the case of Vinod Kumar Swai.
You file it.
File it.
I will place all those judgments.
The So we can take up this matter next week. All right, get ready.
1 week after I play.
All right. The learned counsel for the petitioner. Files one citation in Swansea, which is taken in record. When the learned counsel for the state pointed out rule 6.9, na?
Yes.
6 bracket and 9 of Odisha Civil Services Rehabilitation Assistance Rules 2020, which, according to the Land Council for the state, creates a bar for giving compassionate appointment to the petitioner. Land Council for the petitioner submits that Rule 6.9, 6 bracket and 9 was considered by this court in several decisions, and he will place all those decisions on the next date, and the matter will be taken up a week after.
Yes, sir.
Put of this matter will be commencing from 27th year.
That judgment may continue based on record. The
Yeah, already record. I will not hear him.
Item.